This isn't just one court case. It's a three-part saga of a man given a second, third, and fourth chance, each squandered more spectacularly than the last. We're about to witness Mark Daniel Lewis, a defendant with a troubled past, stand before a judge who seems determined to give him a path to redemption. But this story takes an unbelievable turn. Lewis will make a shocking claim alleging the existence of organized fight nights and rampant drug use inside a state-run rehabilitation facility. His bombshell testimony will earn him a rare opportunity, a golden ticket away from the chaos. But what happens when that ticket is torn up over something as trivial as a haircut? This is a roller coaster of bizarre excuses, devastating confessions, and a judge whose patience is about to be pushed to its absolute limit.
All right, the court is calling 2022 CR 8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For the defense?
Paul J. Smith for the defense.
And are you Mr. Lewis?
Yes, ma'am.
All right, off the record for a moment. All right, we're back on the record. We're here for sentencing. You entered a plea of no contest on November 28. Applied for deferred adjudication.
The defense is painting a picture of a changed man. Mark Lewis claims that becoming a father has fundamentally altered his perspective, a common and often effective appeal for leniency. He's asking for deferred adjudication, a form of probation where, if completed successfully, the charge is dismissed, leaving him without a felony conviction. However, the state is immediately pushing back. They're pointing to his pre-sentence investigation report, or PSI, which details his entire criminal history. For the prosecution, Lewis isn't a reformed father. He's a repeat offender who has already failed on probation before. The judge now has to weigh the man Lewis claims to be today against the man his record says he's always been. It's a classic courtroom dilemma. Is this a genuine plea for help or just another performance?
The court ordered a TAP evaluation and PSI. According to the plea bargaining agreement, punishment is to be assessed at 6 years in the prison. The state is opposing your application. They're taking in consideration County Court Cause number 686624. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
The defense has, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, are there any witnesses, state?
No, Your Honor.
Defense?
Perhaps my client, but his statement is asking for and included in the application. The reason he believes that he can successfully complete a deferred at this point in time of his life.
All right, the court is, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record, please.
Mark Lewis.
All right, defense.
Mr. Lewis, did you file voluntarily a motion for deferred or asking the court to assess punishment by way of a deferred probation?
Yes, I did.
And we've noticed in your report that there have been juvenile incidences and prior instances. Have you, what is it about this application at this time that may result in a favorable outcome for you versus when you were much younger?
Well, of course, when I was younger, I was acting like a kid. I didn't think it would help me. I believed that I could do it my own way. Since that initial time frame, I've been to PUC. I now have a daughter. I've learned what my results will bring me. I was acting like a kid back then. I just thought I could BS my way through it to just try to reach my destination real fast, but I cheated myself.
And do you believe that alcohol and or drugs played a role in the offense that you pled no contest to?
Yes.
Have you got a potential place to live
My bad.
if you were placed on deferred by this court?
At this point in time, I'll be residing at Haven for Hope in PCY Courtyard. My dad lives in Houston. He's looking into assisting me in financially helping me get an apartment within a small time frame, providing that I follow probation rules and successfully do a couple months of course positive living, employment, classes, everything. Then my dad's willing to ask his family to help me with a potential place.
And are you willing to allow the court to help you or address your drug usage?
Yes.
And if the court decides that there should be some classes or some skills or some programs that you attend, are you willing to do that?
Yes.
Are you asking the court for support?
I am.
And is there anything else you'd like to tell the court that we have not covered?
No. I feel like it's been covered.
Ask the witness.
State?
Mr. Hughes, you've been previously placed on disorder, correct?
Yes, sir.
Okay. And there, several NTRs were filed in that case, is that correct?
Yes, sir.
And eventually that did result in the revoke.
Yes.
And shortly after it would have been released, it was the same, but that first offense, it was violation of sex offender registration, correct?
Yes.
Okay. And shortly after that, you were booked again on violation of sex offender registration. Correct?
Yes, sir.
And there you were sentenced to 3 years state jail.
Yeah. 2 years. Yes, sir.
So that might be a typo there, that.
All right. And that offense was related to something that when he was a juvenile, according to what I'm reading.
Right.
And so it was just, let's see, what did they call it? They called it prohibited sexual conduct.
This might be one of the most confusing and bizarre explanations ever offered in a courtroom. Let's try to break this down. Lewis claims he was charging his phone at an outdoor outlet when his charging cord fell into a grate on the ground like an air duct. He says he went down into this grate to retrieve it, but then couldn't get back up to street level. His only way out apparently was through a door that led directly into the hotel he was accused of being in. This story is convoluted, hard to follow, and frankly, sounds unbelievable. The judge's skeptical tone says it all. An explanation like this, which defies simple logic, rarely helps a defendant's case. It often does the opposite, eroding their credibility right when they need it most.
And I see you have gang affiliation.
I did.
And what gang was that?
It was 5 days trip.
Okay. So why were you hanging around this hotel?
I was inebriated. I was charging my phone on a little outlet across from the Starbucks next to the hotel. I was downtown. I take some over-the-counter medication, and time just started fading away. I was charging my phone, and I dropped my charging cord in the grate. So I went away. I came back, and later on that night, I moved grate to get my charging cord, and it actually entered into it was a room, and I couldn't get back up. So I went through the door, and that's how I ended up in the hotel.
Okay, I don't understand your story. What do you mean you went back up?
No, like it was a grate in the ground.
Mhm.
It was like an air duct. My phone cord, when I unplugged it out of the wall port, it had fallen down into that grate. It was like a duct. I couldn't get back up because the ceiling was like up there, the actual street level.
Okay, so where were you charging your phone?
I was charged right across from the Starbucks.
So was it
Hotel.
when you were charging your phone, that wasn't inside a facility, that was outside?
Outside on the street level in the passageway between River Center Mall and Dimension Hotel.
Okay. All right, anything else from either side?
Just argument,
I think your honor, accept the argument.
All right, I have a question, just as soon as probation is available, but I'll hear argument.
Judge, really here, the two charges that he went to TDC for were violation of sex offender registration. Already shown those were conditions that he was given that he had to follow up with. Both occasions he was unable to do that. On the first occasion, it actually was, he was granted deferred. He was given the opportunity to just give out and get help. And he didn't take advantage of it. Motion to revoke eventually filed, and he was sentenced to 18 months in state jail. The state's concern is just that it's a repeated history of not being able to follow regulations or rules that are set out for him. And when he was given a chance, he showed that he wasn't able to follow the rules. And that's where he was revoked and sentenced to prison.
All right. Probation on this case with the violation of sex offender registration. Will SafeP accept him?
No, Your Honor.
ISF?
State ISF,
They will?
yes.
All right. So here's your choice, Mr. Lewis, and I've read the facts of this case. I'm going to give you a choice. State wants you to do 6 years in prison. I can put you on 10 years probation. It's going to be a conviction either way. I'm not giving you deferred adjudication. It will be a conviction. And I will place you on 10 years probation, or I will give you 3 years in the prison. Which would you prefer? And you are going to state ISF.
10 years probation.
All right, that's what the court is going to do. Sentence you to 6 years in the prison, suspended and probated for 10 years. Probation, is there anything else?
Your Honor, you mentioned sex offender, it's gonna have to be on.
The judge lays down a very clear ultimatum, but with a surprising twist. Instead of just revoking him, she offers him a choice, a long 10-year probation sentence, which includes a conviction or a shorter 3-year prison term. Lewis chooses probation, opting for freedom under strict supervision over guaranteed prison time. But the judge adds a powerful condition, a no-contact order with his own biological parents. She's seen in the report that they were homeless and using drugs, and she's severing that tie to protect him from negative influences. Lewis pushes back, claiming his father is his #1 supporter, but the judge doesn't budge. She's seen this pattern before and is trying to build a stable foundation for his probation, even if it means making tough personal decisions for him.
Move caseload or.
Okay, yes, he'll be on that caseload. You're going to be on the sex offender caseload. Not because this is a sex offender case itself, but because of your registration.
Just a few months later, Mark Lewis is back in the same courtroom wearing the same jail-issued uniform. The 10-year probation he fought for is already on the line. The state has filed a motion to revoke, alleging he violated the terms of his supervision. But the reason for this violation is far more complex and shocking than a simple missed appointment or a failed drug test. Lewis is about to make an explosive allegation that will not only determine his own fate, but will also put the very facility meant to rehabilitate him directly under the judge's microscope. This is no longer just about his failure, it's about a potential failure of the entire system.
And have him evaluated for Mick, because I'm reading in here, there's some mental health issues. And I'm also going to do no contact. What are your parents' names?
It's Rhonda Sanford and Matthew Treadway.
All right, you're not to have any contact with your biological parents. Because I've read in the PSI report that you were taken into foster care because your parents were homeless, living out of vehicles, doing drugs. So you're not allowed to have any contact with them. Do you understand?
Your Honor, if I may speak, my birth mom and my birth dad, it was a one-time meet. I recently got in contact with my birth dad in 2020 whenever I paroled out of TBC, and he's my #1 supporter right now. My birth mom, I'm perfectly fine with that, no contact, because she has continued a drug use and like that lifestyle. She currently actually has a drug-related case. So I've already made it a point, and my dad knows this as well, that I don't want anything to do with her. My dad, he's my #1 supporter right now.
Mr. Smith, here's the thing. If you want that changed, your dad is going to have to present himself to the court.
Okay, he lives in Houston now.
All right. Well, he can do it by Zoom. But I'm not going to let you have any contact for now.
Yes, ma'am.
All right. I'm going to show you. Is there anything else, probation, with regards to sentencing? All right. Mr. Lewis, is there anything else you need from the court to be successful?
No, ma'am. Thank you for the time.
All right. Good luck to you.
Yes.
You're welcome. Who's here? Court is calling 2022 CR 8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state?
Hank Wilkins with the state, Your Honor.
Defense.
Ed Piker from Mr. Lewis.
And are you Mark Daniel Lewis?
Yes, Your Honor.
Are you the same Mark Daniel Lewis who is placed on community supervision in 2022 CR 8453 for the offense on unlawfully carrying a weapon with a felony conviction on January 13, 2023 for a term of 10 years? Is that you?
Yes, Your Honor.
State?
Honor, violated condition number 15G, on or about the 26th day of May. And Judge, I'd like to orally.
Oh, just one moment. All right. Are we proceeding on the motion as presented, State?
Judge, we'd like to orally amend, I've conferred with defense counsel. We'd like to orally amend the year. It should be May 2023 instead of May 2026, Judge.
All right, any objection?
Judge, I confer with my client on that.
Did his lawyer just say fight night? This is the moment the case completely pivots. The defense is making an earth-shattering claim that the state-mandated ISF treatment facility is a chaotic, dangerous environment. They're alleging organized fights, widespread K2 drug use, and persistent gang activity. This isn't just a simple excuse for why Lewis failed. It's a whistleblower-level accusation against a state-run institution. If true, it means the government sent a man struggling with addiction and a gang history into an environment that was arguably worse than the streets. The judge's demeanor immediately shifts. She's no longer just listening to a defendant's plea. She's hearing a potential scandal unfold in her courtroom.
And we have no objection.
All right, Mr. Lewis, do you understand that that's a substantive change to the motion to revoke?
Yes, Your Honor.
Do you understand that your attorney has 10 days to prepare for trial?
Yes, Your Honor.
All right, did you wish to proceed?
Yes, Your Honor.
All right, State.
On or about the 26th day of May 2023 in Rusk County, Texas, the defendant, Mark Daniel Lewis, did then and there fail to comply with the rules, regulations, or instructions.
Excuse me, just one moment. Were you changing that date?
Yes, Judge, to 26th day of May 2023.
Okay, all right, thank you. Sorry about that.
Sorry. In Rusk County, Texas, the defendant, Mark Daniel Lewis, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Treatment Facility, in that the defendant was behaviorally discharged from the East Texas State ISF unit in Henderson, Texas, in violation of condition number 15G.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation 15G, the court could find it true, grant the motion, sentence you to 6 years in prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of 15G?
Yes, Your Honor.
Court will find violation of 15G true. Is there an agreement?
Judge, we don't necessarily have an agreement. I have no objection. The defense counsel has spoken with probation and we've conferred. And I think he has a proposal that he'd like to make to the court that the state has no objection to.
All right, Mr. Piker.
That's correct, Judge. And then I will call my client because he knows better what happened.
Mark Lewis's testimony is incredibly compelling. He describes actively trying to participate in the program and making the difficult decision to leave his gang, only to be met with threats of violence. He paints a vivid picture of being caught between a rock and a hard place, either risk his safety in the general population or refuse to go back and violate his probation. The judge is clearly moved by his account. She recognizes the courage it takes to speak out and realizes that sending him back there would be counterproductive, if not dangerous. She literally says, "Thank you for letting me know." And in that moment, Lewis transforms from a probation violator into a credible witness.
I'd ever tell you.
All right, Mr. Piker, what are you requesting?
I am requesting that the court consider keeping him on probation, not revoke him.
And with that, the judge makes a stunning decision. She denies the state's motion to send him to prison and rewards his honesty with another chance, ordering him to a completely different private facility, lifetime recovery. This is a monumental win for Lewis. But as he stands before the judge for a third time, the goodwill he earned has clearly vanished. The question is no longer about the failures of a corrupt facility. The question which the judge is about to ask with palpable frustration is why he threw away the golden opportunity that his own bravery had earned him. What on earth happened at lifetime recovery?
And move him out of, don't revoke him, don't send him back to that facility and send him to lifetime recovery. We've looked into it. It's a 3-month residential. He's motivated. Actually, it was his suggestion that if that was possible to get him out of there, he wants to help. He wants to get off the drugs, but he can't do it where he's at.
Okay.
And he is going to explain that to you better than I can.
All right, Ms. Abrams,
I apologize. I cannot hear.
on this case, it is Mark Daniel Lewis. There was an incident at Henderson, and his attorney is suggesting that he be placed in inpatient at lifetime recovery.
Your Honor, probation would not have any objection.
Okay. And so that I will know, what is the issue with that facility? We'll say allegedly.
Would you like to hear it from me or from Mr. Lewis?
Either one.
Mr. Lewis can explain it better than I, but I will tell you that he was in a gang. He was in a gang when he got there. He wanted out of the gang. He told him he wanted out of the gang. His life was threatened. His well-being was threatened. And quite honestly, from what he tells me, there was so much drug usage there and fight night that it was not conducive to getting better. It made it worse.
All right. And this is at the facility in Henderson, Texas?
Yes, ma'am. He will swear, he will tell you that under oath.
Oh, no, I'm going to make sure that the facility at Henderson, Texas, that we do, that a spot check is done, random, so I can figure out what's going there, because the last thing I want is someone who's trying to get treatment and wants treatment to be sent to a facility where it's difficult to receive that.
And that's why I wanted to address you, because I knew you'd be interested.
All right. You want to raise your
The judge cuts right to the chase, and her memory is sharp. She recounts the entire Fight Club saga, reminding everyone in the room that she gave Lewis a special exception based on his testimony. She explicitly states that he was supposed to be at lifetime recovery and that people seem to be leaving the facility without her permission. Her frustration is boiling over. She trusted him, believed his story, and went out on a limb for him. Now he's back in front of her after absconding from the very place he was sent for his own safety and rehabilitation. She poses two simple, brutal questions. Why did you leave? And why shouldn't I revoke you and send you to prison? His answer better be good.
right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name.
Mark Lewis.
All right, so tell me what is going on at the Henderson facility.
Whenever I was here in this courtroom on January 13th, I signed for the 10 years probation. You gave me the choice to go receive help or go to TDC where, so I chose the help. And whenever I was finally transported to Henderson, Texas, I threw myself into the program and I started learning about thinking errors. I started learning all the aspects I needed to learn for my first track, which was cognitive intervention. And had a very successful 45-day call. But during that time, I made the decision to step away from the gang affiliation that I was affiliated with, and I made it known that they were doing fight nights. There were people over there still smoking K2.
Fight nights?
Yeah, it was disrupted. The counselors would come in and they would read from a piece of paper for an hour, and they would leave until the next day, and it was back to the same stuff. And I made it known that I didn't want no part of any of that anymore. I was trying to get back to my daughter. I let everybody know, like I was back in my Bible. I was trying to get myself right. And a lot of people took that offensive, and they threatened me, and they were trying to jump me. And thankfully the guard was able to see that something was going on, and they pulled me out of the dorm that I was in, and they placed me in
This is a devastatingly weak excuse. After everything he's been through, exposing a corrupt facility, earning a rare second chance from a compassionate judge, his reason for throwing it all away is that he panicked over a write-up for getting an unauthorized haircut. He even admits he jumped to conclusions and reacted wrong. He was just 2 weeks from completing the program. 2 weeks to abandon his progress and freedom over a minor rule infraction he wasn't even sure would violate him is a catastrophic failure of judgment. You can almost see the hope and patience draining from the judge's face as she listens to this flimsy, self-sabotaging explanation.
a single man cell in restrictive housing. And when they came,
This is the tragic and predictable outcome of his decision to flee. Lewis confesses to an immediate and severe relapse into IV meth use. The physical toll is so apparent that the judge herself remarks on it, saying, "Oh no, I can tell by your appearance." It's a heartbreakingly candid moment that underscores the severity of his addiction. Just a few months ago, he was a sympathetic whistleblower, a man who seemed to be fighting to change his life against a corrupt system. Now he's a man who has visibly lost that battle, admitting he found himself only to lose it all again. His own actions, not a corrupt facility, are the reason he's back in chains.
they were like, they wanted to send me back to that environment. And I wasn't trying to go back to that environment because of the threat. And they said that by refusing that environment, I was refusing the program. And I knew that I would have to come back here and address you, but I'm trying to do better.
Okay. No, I appreciate that. So what I'll do then is I'll deny the motion and I'm going to alter and amend conditions to include lifetime recovery, the inpatient, and you'll be transferred from the jail to lifetime recovery.
Yes, Sean.
All right. Is there anything else?
That was it.
All right, we can go off the record. See what I mean about communication being key? If I don't know this is going on, then, but thank you so much for letting me know.
Thank you, Your Honor.
You didn't get any more tattoos while you were there, did
No,
you?
thankfully not.
Okay.
Thankfully not.
And he's not from Indiana.
Okay.
Okay.
All right.
All right,
Thank
thank you,
you.
Your Honor.
Thank you for letting me know.
Thank you.
All right. Court is going to call 2022 CR 8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state? Defense.
I'm here Memorial, Your Honor.
And are you Mr. Lewis?
Yes, Your Honor, I have.
All right, Mr. Lewis, did you review the document counsel, you're on this side. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor, I did.
Are you the same Mark Daniel Lewis who is placed on community?
The judge delivers her final warning, and the tone is ice cold. There is no more sympathy, no more room for excuses. She lays out the reality of his situation with brutal clarity. If he comes back again for any reason, whether it's his fault or someone else's, she will revoke his probation and sentence him to prison for up to 6 years. The tears, which she pointedly notes, will not work anymore. This is it. This is the absolute end of the line. She has exhausted all her options and all her patience. He has one final razor-thin path to walk, and any misstep will lead directly to a prison cell.
Supervision in 2022 CR 8453 for the offense of unlawfully carrying a weapon with a felony conviction on January 13, 2023 for a term of 10 years. Is that you?
Yes, Your Honor.
State.
Violated condition number 4 in Bexar County, Texas. The defendant, Mark Daniel Lewis, did then and there fail to report to the supervision officer as directed for the months of October and November 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
No objections.
All right. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 6 years in the prison?
Yes, Your Honor, I do.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor, I do.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Your Honor, I think that the state's going to make one recommendation and the defense is going to request something else.
All right.
But the state is requesting state ISF followed by gang/ISP and then to hold GPS and SOMU in advance.
All right. And defense, what are you requesting?
Judge, couple of things. Mr. Lewis understands the seriousness of what he's facing, Judge. In the state ISF, my understanding is where he got into trouble before, correct?
Yes.
And so he was in lifetime recovery, Judge. That's what he's requesting the court to give him the opportunity to prove himself, get back on treatment with lifetime recovery. Judge, I also have a letter from a Mr. Juan Trejo attesting to Mark's character, Judge. I don't know if you want to see that or not.
Oh, sure. Thank you. So here's my question. I remember him. He's been before me previously, and previously it was a violation of 15G. He said that there were issues with ISF. I believe he said, I think either people were doing drugs or something else was going on in treatment. Or either, no, someone was trying to fight someone, or they had Fight Club at the ISF. And I said, okay, we're going to check into that. And then what I ordered after he pled true to violation of 15G, I denied the motion, and it was the alternate mean conditions, and he was supposed to go to lifetime recovery. And people, it seems, are leaving lifetime recovery without telling me and leaving without my permission. So we need to start with 1, why did he leave lifetime recovery? And 2, why shouldn't I revoke him and send him to prison? So that's where I am.
If I can, I'll have
Sure.
to answer the first question.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Mark Lewis.
All right.
Mr. Lewis, if you can tell the court why you left lifetime recovery the first time, sir.
I had gotten placed on a zero tolerance contract with my counselor.
Mhm.
I was sent there by yourself, Your Honor, for the period of the 3-month program, and I was 2 weeks away from completion when placed on a zero contact order because somebody there had left his cell phone and they assumed it was mine and it wasn't, but that's beyond the point. I was on a zero tolerance order and then I gotten in trouble and somebody was cutting hair there and they were cutting my hair and they came and they said they're gonna write both of us up. And I took that to mean that they were going to violate the zero tolerance order. So I jumped to conclusions and I reacted wrong and I left. I have no other excuse besides that, no other reason. That's what happened and that's why that did happen. But I was doing the program and I was 2 weeks from completion when all that happened and everything just.
And what drugs have you been using since we have not seen you?
Honestly, I got back on IV usage of methamphetamine. I gotten really bad, like within 2 weeks of.
Oh, no, I can tell by your appearance.
Yes, ma'am. I gotten really bad within 2 weeks of there, and I really wanted to. I had found myself. I lost it again.
All right, so here's the thing. I'm not sending him to lifetime recovery. He is going to safety, or either if felony drug court accepts him, he can be at felony drug court, but he is not going back to lifetime recovery. So those are his choices.
Judge, I would suggest that we go to safety first and give him the opportunity to go into treatment and get that done, Judge.
All right, anything else from either side? All right, violation of condition number 4 is true. I'm going to deny the motion, alter and amend conditions to include safety. And we can refer him to felony drug court. I don't think they're going to accept him if there's a gang issue with him. He's to remain in custody until transferred to safety or felony drug court.
Your Honor, if he does not qualify for safety due to his sex offender registration, would the court consider state ISF again?
All right.
And Judge, I'm checking on that with our coordinator for safety to find out if they'll take him, if it's just registration and not the current offense.
Okay. So we'll do safety or felony drug court. If for some reason neither of those places will take him, we'll bring him back here and I'll consider something else. And he's to remain in custody until transfer. And there is going to be GPS, partial for treatment, any probation visits, and work only. If you come back here again, your fault, somebody else's fault, what's going to end up happening is they're going to file a motion to revoke and you're looking up to 6 years in prison. And this tier thing, not going to work.
And Judge, I did confirm they will not accept him at safety due to his registration requirements.
All right, we'll see if felony drug court will take him. If they do not, then, well, so you all want to come back. If felony drug court does not accept him, then state ISF, that's cognitive and substance abuse.
I only do one track.
All right, substance abuse track then. All right, is there anything else?
Not for that, no. Thank you very much.
You're welcome.
Maybe it's you, Your Honor.
In the end, Mark Lewis's saga comes full circle. After being saved from one corrupt facility, he now faces the very real possibility of being sent right back to it if other options fall through. The judge, having offered chance after chance, is left with a difficult choice: lock him up or send him into a system he himself exposed as flawed. Lewis's story is a powerful reminder that the path to redemption requires more than just good intentions. It demands accountability and the strength to face consequences, not run from them. The judge made it clear the tears won't work anymore. Was she too lenient, or did she do everything possible for a man who wouldn't help himself? Comment below with your verdict and subscribe for more in-depth courtroom analysis.